Closing arguments begin today in the Colorado theater shooting trial. The prosecution says that gunman James Holmes knew what he was doing and deserves the death penalty.
But the defense is arguing that Holmes was insane at the time of the attack. So, to join us to talk about this, legal analyst Rikki Klieman is here. Rikki, thanks for being with us.
Thank you.
So, what are we expecting from closing arguments today?
I think that closing arguments are going to be both highly emotional and technical. You are really dealing with the nuts and bolts of the issue, which is the insanity defense, rather than the intricacies of 2 counts of murder, 2 theories for each victim, or 2 counts of attempted murder and theories for the attempted murder. What you have is a battle of experts, but perhaps it's more than that. You have 2 psychiatrists who have said for the government that he, although suffering from mental illness, was certainly sane under Colorado law. You have 2 psychiatrists from the defense who say no, very clearly on the schizophrenia chart, and within that he could not decide right from wrong. So you have this battle. In addition to that, you have a lot of visuals. You've had over 22 hours of interviews, video interviews of the defendant by the psychiatrist that the jurors have seen. And you have the way the defense ended their case. Very powerful in a case that seems to not favor the defense, and yet they could get up to the end and say, let's show a video of the defendant throwing himself headfirst against a wall, falling down, throwing himself, falling down. Let's show a video of him being restrained, where he's trying to put blankets over his head. Let's talk about his odd behavior with his hands during the gun residue test. There are signs that go with the defense theory of the case. And the defense theory of the case is that he was in the midst of a psychotic episode. On the other hand, these jurors have been through carnage. It's been like the Boston Marathon bombing. They have been through every injury, every killing. And so it is very difficult for them to go further and find him.
We've heard emotional testimony and seen graphic evidence.
Day by day.
Yes.
So they're in it. These are people who counseling will be prescribed if people want it after they have served as jurors. We put our jurors through extraordinary mental stimulation and distress in a trial of this magnitude.
During closing arguments like this, in a case as complex as this and with arguments on both sides strong, let's say from the jury's point of view, when they're listening to closing arguments, how does the defense and the prosecution go at trying to just consolidate this for the juror, to try to put it into simpler terms? Because who can handle all of that?
Well, I think that you are correct that simpler terms and consolidation is necessary. You've got a 2-hour closing argument limit for both sides. Prosecution can divide theirs, both their opening closing argument, if you will, and then a rebuttal closing argument. The defense is in the middle. Perhaps always appropriate because the prosecution has the burden of proof. And in this case, they have been instructed, as I was listening to the instructions, they've been instructed that the prosecution must prove that the defendant was sane, or in other words, show that he was not insane. That's a big burden of proof. So how does the prosecution really get them to focus on the planning and the preparation that it was outside the defendant's delusional system? And on the other hand, the defense, with not a legal burden, but a real emotional burden, has got to say, look, this is a person who is mentally ill. One interesting thing I wanted to add for you, because it was in my ear and when I was by the monitor in my eyesight, there was an instruction that went to this jury on the aspect of what happens to a defendant who is found not guilty by reason of insanity. That instruction is very rarely given around the country. So they know that he's committed to an institution if found guilty. If found not guilty by reason of insanity.
If found not guilty by reason of insanity.
But they also know that he's eligible for release if, in fact, a time should come where he's considered sane and not a danger.
The judge instructs them that? They tell them that?
I almost fell off my seat.
I was going to say, because that may influence their decision.
For sure.
It could definitely influence their decision. Now, it would be interesting for me as a lawyer and perhaps for some of our viewers, to find out who wanted that instruction.
Yeah.
Did the prosecution want it, or did the defense want it?
And if he is found guilty, they've asked for the death penalty, but Colorado has not executed somebody in some 20 years, right?
A long, long time. And of course, in a situation like this, if he is found guilty, the same jury will then decide whether or not he lives or dies. And that process, as we know, again, just from visiting it in the Tsarnaev case, the Boston bombing case, that the death process, the question of what's the ultimate punishment, that's a whole long hearing in and of itself. And of course, we understand, as you say, 20 years, the appellate process will take years on end.
All right, Rikki Klieman, you're going to be with us for the next couple of hours as we watch what happens there in Colorado. In fact, the jury has just gone to recess. They're out for lunch, so we're going to keep you around and keep talking about this in the hours ahead. Rikki Klieman, thank you so much.
Thank you.
Rikki.